I'll be speaking with you later in the hour about what's happening on the litigation front in the antitrust space. But there's no doubt that Washington, D.C. is the center of the antitrust world. The tone is set by the federal regulators who are charged with enforcing antitrust law. They have a huge impact on the cases that get filed around the country and the deals that get done in the energy and chemical sectors. So that's where we have to start our discussion, and there's no one better to lead that discussion than Darren Tucker. Darren's based in our Washington office. He's been practicing in the antitrust space for 25 years, both in private practice and as counsel to the Federal Trade Commission, where he was an advisor to Commissioners Joshua Wright and Tom Roche on enforcement and policy issues. Today, Darren works with our clients in all aspects of antitrust, whether they're facing governmental investigations here at home or abroad, or engaging in major transactions that will undergo regulatory scrutiny. He's also one of the senior leaders of the American Bar Association section of antitrust law. He's currently serving as the finance officer for that group, which is the world's largest competition law organization. Darren, why don't you tell us what's on the agenda for today and what you're seeing in DC?
Thanks so much, Jason, and it's a pleasure to speak with all of you today remotely. Thank you for joining us, notwithstanding the really lousy weather we have in much of the country. So it's a pleasure to speak with you any way that we can. So we have a packed agenda, so let me just kind of give you an overview of what we plan to cover today. So I'll start off just with some kind of key agency enforcement takeaways. This is sort of the, if you have to try to remember 5 or 10 minutes of what I'm going to cover, this would be kind of the key part. I'll quickly go through an overview of our key antitrust enforcers at the federal level, spend most of my time on developments in merger review and enforcement, very quickly on non-merger enforcement, where there really were not a lot of developments last year, and then hand it back to Jason. So let me sort of start with kind of the big picture. So, when I'm speaking in these kind of programs, in person, whether it's a conference or other CLE program, I typically, have people grab me before or after and ask me essentially the same question or some version of the same question, which is, can I get my deals through the agency? Or, what do I really need to know in 5 minutes in terms of, what's changing at the FTC or the DOJ in terms of, getting my deals through. So let me just sort of address that right up front. So, the short answer is it is more difficult. It is more challenging to get your deals through the FTC and DOJ today than it has been in other recent administrations, both Republican and Democratic administrations. The Biden administration enforcers are more aggressive. They're bringing and trying to bring more cases. And as I'll talk about, there's kind of a wider range of concerns that they are expressing. But at the same time, the sky's not falling. Right? The vast majority of deals are still getting done, including in the energy and chemical space. But what's really changing is two things I wanted to really focus on. One is that merger enforcement has become much less predictable. It is much harder to determine at the outset which deals are going to get caught up in an extended review at the agencies, which deals will spend, 6, 9, 12 months or longer before the agencies with an in-depth review. And the other big development is it's just taking a lot longer to get deals through. And this is really a continuation of, I think, existing trends from previous administrations, but it's gotten worse in the current administration. It just takes longer to get a deal done if you get caught up in one of these second request investigations. Those are the in-depth investigations where the agencies want to really dig in to the deals. So why is that? Why are we seeing those two trends? So in my view, there's actually a common thread, kind of a common cause behind each of these, which is that the agencies have more theories of harm today than they have in the past. And let me explain what that means, because it sounds a little esoteric. So, with any transaction, essentially what the agencies are doing is they're trying to figure out, will this deal raise prices to consumers or whoever's buying the product? Right? I mean, it's essentially a very simple inquiry at the end of the day. But of course, there's lots of transactions between competitors that don't raise prices, and there's lots of transactions between competitors that actually lead to lower prices. So it's not necessarily the case that a combination between competitors is going to raise prices. there has to be some reason to think that a particular deal is going to lead to higher prices. And so that's where a theory of harm comes into play. It's essentially a story. It's a story of why this particular deal is going to lead to higher prices. And going back to at least the 1980s, maybe even before that, there were essentially three major theories of harm. I won't go into them, because it's a little more detailed than we have time for, but they're called unilateral effects, coordinated effects, and then vertical sort of foreclosure theories of harm. So we basically had three theories of harm we were looking at, up to three theories of harm in any particular deal. Well, now there's a lot more than three. I couldn't even tell you how many there are, but it's more than doubled, if not tripled, today, in terms of the number of types of theories or stories the agencies are trying to tell when they're looking at a deal. So what's the impact of that? Well, if you're, someone in my position who's trying to identify which deals are going to get agency scrutiny, it's a lot harder if you're looking at, eight or nine potential ways a transaction might be problematic versus three, right? There's a greater chance of error. It's just harder to predict what the agencies are going to do when they're looking at so many different things on a transaction, especially when a lot of these theories of harm are relatively new and untested. And then also, an agency isn't limited to just one theory of harm. They could look at as many as they want. So in the past, maybe they would look at one or two theories of harm in an investigation, whereas now they might be looking at two, three, four, or five. And with all those additional theories of harm mean a lot more information that the agencies are going to want to get, which means broader second requests, more interrogatories, more documents, more investigational hearings, which is the FTC term for depositions. And all of this just takes more time. With more information comes more time. But again, the sky's not falling. Most deals are getting done, but we do have this much greater, much less predictability, I should say, and more time needed. Again, to go back to the sky is not falling theme, we had kind of an unusual situation in 2023 in terms of enforcement in the chemicals and energy space. We typically see about three or four merger enforcement actions in those industries combined each year coming out of the two agencies. Last year, we only had one. That was pretty extraordinary. We had just one energy deal and zero chemical deals where the agencies brought a merger enforcement action. So is that a beginning of a trend? I don't think so. I think it's probably a statistical blip. That some years there's more than three or four enforcement actions, some year there's fewer than three or four. I think we just got kind of a random blip where there were fewer than usual. I think that especially with some of the bigger deals that have been announced going into 2024, we're likely to see, I think, kind of a return to sort of the normal levels of enforcement cases brought in those sectors. Beyond those sort of macro trends, there was one pretty big development in the merger space, which I'll come back to later, but I'll just kind of preview now, which is the agencies put out new merger enforcement guidelines just about a month ago. These are pretty significant policy statements. It's probably the most significant policy statement the two agencies put out in the antitrust area. They put these out about once a decade, and it's essentially an explanation of sort of the theories of harm and the methodologies the agencies apply when looking at a transaction that's before them. So it's essentially just a policy statement. It just explains how they're going to look at a deal. It just at a high level. And what we're seeing is, as I mentioned before, there's a lot more theories of harm, and you see that reflected in these new merger guidelines. And so in that sense, they're terrific, right? They're actually explaining the agency's current thinking, whether you agree with them or not. At least they're explaining how they're going to look at deals so that you can at least share a common language and provide advocacy to the agencies that will, be something that might resonate with them, as opposed to ship sailing in the night where we're making an argument that they just don't find is really relevant. But the downside with these new guidelines is, they're very expansive. Again, they reflect all these new theories of harm. And the result is it's a pretty big divergence from the previous merger guidelines. It's a pretty big divergence from previous agency practice. And maybe most significantly, it's a pretty big divergence from the standards the courts are applying. So, the FTC and DOJ can't just wave a wand and block a deal. They have to go into court and get an injunction, preliminary or permanent injunction. And so as a result of that, there's been a pretty substantial body of case law that's built up over time. Now, these are the lower courts. The Supreme Court doesn't look at these cases very often, but in the lower courts, there's a lot of cases that have developed. And so, the courts have a certain standard that they apply. And, the agencies are applying now a very different standard than the courts. And I'm not sure that that's really a great development, just as a policy matter. But there's also a pretty important practical implication of that, which is that if you have a transaction that's running into scrutiny at the FTC or DOJ, you might decide to roll the dice and actually litigate against the agencies, much more frequently than you might in the past, right? Because if the standard for review is much lower at the courts than the agencies, you might want to just stick it out and take a shot before the courts. And I think more companies will do that, and I expect we'll see a lot of wins actually when companies are willing to do that. But the downside is you've now got to tack on yet another 6 months to what might already be a year-long process of the agencies looking at your deal. So again, this goes back to this theme of reviews taking longer and longer. The other big trend I'll just touch on now and come back to in more detail later is labor market concerns. Traditionally, antitrust agencies have focused on down market concerns. So basically the sale of a product to somebody else, to a retailer, a wholesaler, or something like that. And again, what you look at is, will prices go up? Well, since this really started in the Trump administration, but has expanded even more in the Biden administration, there's been a focus on labor market concerns. So not looking at the sale of products, but actually for the purchase of inputs. And the antitrust laws, actually, there's good case law on this going back, over 100 years, saying the antitrust laws apply to the purchase of products just as much as they do to the sale of products. And so the agencies have said, we will look in merger reviews at labor market concerns as an independent concern, even if there's no impact on downstream prices or down market prices. They're also looking at things like non-compete agreements and just looking at potentially a rulemaking in that area. So there's a lot of activity kind of in the labor market area. So with that fairly lengthy overview, let me kind of go into some more details. So we have, of course, two federal antitrust enforcers, and then, of course, it's important not to forget we do have, 50 or more than 50 actually state level antitrust enforcers as well. State AGs can enforce federal antitrust law, and most states have their own antitrust statutes. But at the federal level, which is what I'll focus on, we have the FTC, which is currently headed by Chair Lina Khan. We have kind of an unusual situation at the FTC right now. There's, of course, 5 seats at the top of the agency, 5 commissioner seats. Currently, 2 of them are vacant, and the 2 vacancies are the Republican seats. So we have right now 3 Democrats, including a Democratic chair, and 0 Republicans. And we've had that situation since last spring. There are 2 nominees, and they've actually been pending for, I think, about 6 months or so now. I don't really have any inside the Beltway insight on when they're likely to be confirmed. Over at the DOJ, there's a little bit maybe less drama. We've had Jonathan Cantor heading up the antitrust division since shortly after Biden came into office. So focusing now on merger enforcement, this is kind of where I'll spend most of my time. As I mentioned at the outset, we had a pretty substantial development just a month ago with the issuance of new merger enforcement guidelines. It's important for me to emphasize these are not legally binding on the courts. These are just guidelines for the agencies themselves in terms of how they approach merger reviews. They're actually not even technically binding on the agencies themselves, but they at least set forth the agency's general policy on merger review. In the past, they have actually been pretty influential with the courts. Again, it's not law, but agencies have found the guidelines to be essentially persuasive and have looked at them from time to time. So it'll be interesting to see if that's the case with the current guidelines. As I mentioned at the outset, I think the guidelines do a really nice job of basically encapsulating the last couple of years of speeches that we've heard from various enforcement officials at the 2 agencies, as well as some recent enforcement cases, in terms of a much more expansive set of theories of harm that the agencies are looking at. So a few of those, again, to just sort of touch on, I mentioned already, labor market concerns. This is now a standalone concern. So again, if you have a deal that results in, or the agencies think the deal will result in lower wages for employees of the combined company, that could be an independent basis to challenge the deal, even if there's no impact on prices sold to consumers, or even if the lower labor rates lead to lower prices for consumers, that could still be problematic under the new guidelines. There's also a concern with serial acquisitions, and the agencies use different terms for this, but one of them is serial acquisition. It's basically the idea that a company might do a series of small acquisitions that essentially are below the radar. They might not be HSR reportable. They might be so small that no one's really paying attention, but you do a whole series of acquisitions in the same general space, the same general product category. And at the end of that, you've done so many deals that the net result in the agency's view is that you've achieved market power and you've achieved an anti-competitive result. And so the agencies essentially are saying, we're not going to look at this as a series of acquisitions. We're not going to look at each one by itself. We're going to look at the group as a whole, basically aggregate all of these deals into one and ask ourselves, is that aggregated deal anti-competitive? And of course, this lowers the burden of proof for the agencies, if you're applying that kind of a framework. Um, let's skip the next point here. So somewhat confusingly, the 2023 merger guidelines themselves have within them 11 discrete guidelines. So when you're talking about the guidelines, you have to kind of be clear what you're talking about. I won't go through all 11 of them, but let me just touch on a handful of them just so you can kind of get a sense of some of the changes here. So one of them is adding a bright line threshold, which says if the combined company will have a 30% market share, when two companies are competitors pre-deal and they'll result in 30% combined market share, the deal is presumptively illegal. Now, you may ask, well, what if you're below 30%? Will the deal be presumptively legal? And the answer to that is no. The guidelines specifically say if you're above 30% presumptively illegal, but below 30%, no presumption applies. And you'll see that that's a theme of the guidelines. There's lots of these theories of harm that say, if the evidence shows a certain something, your deal is presumptively illegal, but they never say your deal is presumptively legal if that condition does not apply. And similarly, the guidelines have been around since 1968. And again, they are revised from time to time. And the guidelines have always had a definition of what is a highly concentrated market. And that's changed over time. And the reason why there is a definition of a highly concentrated market is deals that take place in a highly concentrated market will be more strictly scrutinized than others. That's a pretty consistent theme across the guidelines, again, going back all the way to 1968, to the very first version. But the definition of what is a highly concentrated market has changed with almost every guideline that's been put out. And the general trend has been that the threshold gets higher each time. So the 1968 guidelines had a pretty low threshold for what is a highly concentrated market. And the later ones moved it up, in the 80s, and then the 92 guidelines and the 2010 guidelines. These guidelines shift. So now we're going back down, right? So it's now a lower threshold for what is a highly concentrated market, which means more deals will be presumptively problematic, or at least a higher threshold will apply. Or so I should say a lower threshold for scrutiny will apply because more deals will fall within a highly concentrated market. Some other guidelines, there's greater scrutiny to companies that have a dominant position. So if you're already a strong player in an industry, even an acquisition of a very small company or a company that's just getting into the market could be illegal in the agency's mind. Again, there's more of a focus on these roll-up or serial acquisition strategies, more of a weight on potential competition theories of harm. And there have been challenges on this before, so this is not entirely new. But again, just to kind of give you an example of just how expansive these guidelines are, there's a particular type of potential competition theory, which we don't need to go into the details on, but essentially the Supreme Court announced this theory back in the early 70s. And there's never been a successful case brought on this potential theory of harm. Yet here it is very prominent in the merger guidelines for the first time, or at least first time in a long time. So again, we see with a lot of these guidelines are essentially blasts to the past. We're basically taking enforcement approaches from the 60s or 70s and trying to reinvigorate them. So let me talk next, maybe a little bit quicker, about a couple of other trends, and I'll talk about two cases that I think are interesting, that are relevant, again, in the energy and chemical sectors. So if you go back to the Trump administration, There was virtually no mention of the energy industry at all by the FTC or the Antitrust Division. So the FTC and the DOJ, officials, give a lot of speeches. They provide a lot of testimony to Congress. They put out a lot of reports, and they tend to, talk about what their concerns are. They talk about what's on their mind, and so you do see certain industries highlighted, different times. And again, prior to the Biden administration, there was virtually no mention at all, of the energy industry. What you would typically see are the enforcers talking about problems that they perceived in the tech space, pharmaceuticals, and some other areas like real estate, for example, but virtually nothing on energy. Well, that's been a big change. We're seeing a lot more rhetoric coming out of the agencies about perceived antitrust concerns in the energy space. There's statements from Lena Khan, for example. She believes that there's too much concentration in the oil and gas markets, that the FTC and DOJ let some deals through in the past that they shouldn't have. And this concern is not unique to the FTC and DOJ. We're seeing on the Hill some concerns about consolidation in the energy space as well. And a good example of that is just a couple of months ago, 23 senators expressed concerns to the FTC about the ExxonMobil Pioneer deal, as well as the Chevron Hess deal. And I should just mention that the FTC has actually issued second requests in both of those deals, according to public reporting, which means the FTC is going to be taking an in-depth look at both of those deals. A couple of other things that are worth mentioning. Again, if you go back to some early speeches from FTC Chair Khan and some of her deputies, there was some very, very negative rhetoric about private equity firms. Just a lot of criticism of the entire private equity model of business, frankly, it was pretty striking. So we've been kind of wondering what that was going to result in, and we're starting to see that. But we are seeing some cases brought against PE firms, although they are a bit more targeted than some of the early rhetoric was suggested. So one of the things we're seeing again is concern around these roll-up or so-called serial acquisitions. The FTC brought a case last year against a PE firm where the FTC alleges that the PE firm essentially bought up nearly every large anesthesia practice in Texas to create a single dominant provider. Those are the FTC's words, with the goal of trying to get higher reimbursement rates from payers. That case is still pending. Then another thing that we're seeing in terms of kind of an interesting trend is a focus on kind of an esoteric topic, even to antitrust lawyers, frankly, which is it's called interlocking directorates. Section 8 of the Clayton Act prohibits someone from serving as an officer or director on competing corporations. And it's a per se rule. You can't justify it. There are some de minimis exceptions. But there really has not been a lot of enforcement on this going back decades, frankly. But we've seen this reinvigorated at both agencies. So about a year and a half ago or so, the DOJ sent letters out to a few dozen individuals that it thought might be in violation of Section 8. And there was a flurry of people resigning directorships as a result of the DOJ sending these letters out. Then more recently, we're seeing the FTC actually try to enforce Section 8 of the Clayton Act in merger reviews. So that takes us to the first case I wanted to talk about. And this is the one case that I've sort of referenced already. This is the one merger enforcement case last year in the energy space. And as you'll see, it's a pretty unusual case, very unusual, actually. So let me give a little bit of background here. This is the case involving a combination between EQT and Quantum Energy Partners. Probably most of you know EQT is the largest natural gas producer in the Appalachia region. Quantum also has, which is a PE firm, they also have significant holdings in Appalachia for natural gas. In the particular deal here, Quantum was going to sell two of its subsidiaries in the Appalachia region to EQT. And the consideration for this was Quantum would receive essentially 11% of EQT's equity, as well as the right to one seat on EQT's board. And the FTC challenged this, and the parties entered into a consent decree to resolve the FTC's concerns. But there was a lot of things that were unusual here. So first of all, the FTC did not challenge the main deal. The FTC did not challenge EQT's acquisition of the two quantum subsidiaries. That was the main deal. FTC didn't have concerns about that, or at least they didn't bring a case on. What the FTC challenged was what antitrust lawyers would call the backside deal. It was the consideration for the main deal, where Quantum obtained the 11% interest in EQT and the board seat. So what was the FTC's concern? Well, the FTC alleged that Quantum, still had some other Appalachia holdings after this deal. So EQT and Quantum were at least tangentially competitors for the supply of natural gas, coming out of the Appalachia region. And so having a minority interest in Quantum could facilitate, anti-competitive conduct between the two companies in that region, as well as exchanging, could at least essentially lead to a conduit of exchange of competitively sensitive information between the two companies through this shared directive. So that was basically the theory. This was, pretty unparalleled in terms of a case. So this was a case brought under Section 5 of the FTC Act and Section 8 of the Clayton Act. Those are not merger enforcement statutes. The merger enforcement statute is Section 7 of the Clayton Act. So right off the bat, the fact that they did not bring this case under the merger enforcement statute is quite remarkable just at the outset. Also, it was interesting, this was the first time the FTC had brought a case under Section 8 of the Clayton Act in 40 years. Which goes to show that they really did mean when they said that they wanted to reinvigorate Section 8 enforcement. So what was the result here? So the parties entered into a consent agreement, essentially was sort of unwinding the backside deal, if you will. So Quantum was barred from appointing a board member, and they had to divest all of their shares in EQT over a period of time that was undisclosed. So a very interesting case. I will say that I think it's relatively safe to say that no prior administration, at least no recent prior administration, would have brought this case. This is not a case I think either the Obama or Trump administration would have brought. I also think there's a pretty good chance the FTC would have lost this case if they had actually litigated it, as opposed to reaching a consent agreement. So again, and this would have had pretty significant impact on the FTC's authority to have a loss here in court. So it just goes to show just how aggressive they're being in terms of their enforcement of some of their priorities, at least. Another case I'll mention, which again sort of highlights just how aggressive the FTC is being in some enforcement matters, is a case that kind of fell below the radar last year, which for the most part for good reason. It's not, at least so far, not that significant, but again, just sort of highlights some of the points I was just mentioning. So this is a case that goes back to 2018. 7-Eleven acquired 1,100 retail fuel outlets from Sunoco. At least at that point, it was a relatively routine kind of merger review, at least from looking at it on the outside. These are like hyper local analyses. So you look at each retail fuel outlet. Are there overlaps at a 1 mile, 3 mile, 5 mile radius, things like that. And as a result of that analysis, the FTC concluded that there were, I think it was 59, of these 1,100 fuel stations, that there was an overlap with a 7-Eleven station that was problematic. So the parties agreed to divest or to sell back these stations. So that was all, fairly routine, at least at a high level. But then fast forward a few years, and the FTC sues 7-Eleven for violating the consent agreement back from 2018. So what happened? So as part of that consent agreement, not only did 7-Eleven agree to divest a bunch of stores, they also agreed not to acquire a bunch of other stores that the FTC determined in the course of its review that would have been problematic for 7-Eleven to own, that also would have been anti-competitive. So 7-Eleven agreed to that as part of their consent agreement, but the FTC alleges that 7-Eleven actually went and then acquired one of those stores that agreed not to acquire in that settlement agreement with the FTC. And so the FTC sued last month to obtain civil penalties. The FTC alleges that 7-Eleven does not dispute the violation, which essentially means that the only thing that they're arguing about is what is the civil penalty. Now, the complaint filed by the FTC is heavily redacted, so there's a lot of information we don't really know here. But I would say, just from my experience, just rough rule of thumb, a retail fuel outlet might be worth $5 million, just on average. Maybe a little more. It really depends on the location. So you might think that that would be maybe an upward bound for what the FTC might try to get in terms of a civil penalty. But in fact, the FTC is seeking a $77.5 million civil penalty. Again, order of magnitude of 15 times, roughly speaking, 15 times greater than probably the value of the station at issue here. Is the FTC going to actually get this? No. I think a federal court is going to pull that back quite a bit. But the mere fact that they couldn't reach an agreement with 7-Eleven on this, went into court trying to get such an incredibly high civil penalty, again, shows sort of the aggressiveness with which we see the FTC these days. I'm running a little short on time, so let me skip this. I'll just touch on this quickly. One other development in 2023, kind of heading into 2024, when parties have an obligation to submit an HSR filing, it's a Hart-Scott-Rodino filing. That's where you have a transaction that hits a certain threshold, and then you have to notify the government and wait 30 days typically for the agency to review your deal. The HSR form has remained, largely static, for quite a while. And the FTC proposed a really, really substantial revision to the form last year. It's currently still under consideration. There was a public comment period that closed in September. But if the final requirement is anything like the initial proposal the FTC put out for public comment last year, this is going to be significantly more burdensome and costly for companies. So for companies that are doing an in-house counsel that are responsible for HSR filings and kind of managing that process, keep in mind this is going to take a lot longer, and it's going to require higher legal fees to manage those processes going forward. A couple other quick developments. There have also been some changes to the filing fee threshold. This came from an act of Congress, not from the agencies themselves. It used to be $280,000 was the highest filing fee. We're now up to $2.25 million for the largest deals. So these fees have gone up quite a bit, except for the very smallest deals. A couple of other things, folks who do a lot of deals may know. There used to be this thing called early termination of the HSR waiting period. So if you had a deal, you did your HSR filings, and the agencies concluded prior to the end of that 30-day waiting period that the deal was not problematic, the agencies could issue early termination and say, okay, we finished our review, go ahead and close your deal. We don't have any concerns. And they eliminated that back in February 2021 on a so-called temporary basis, but have still not resumed the grant of early terminations. So that is, yet one more reason why merger reviews are taking longer. The DOJ is very hostile to divestitures. This is not really news. This has been a trend over the last few years since Jonathan Cantor came into office. So it used to be when you have a deal that was running into problems, you could, fight it out in court. You could abandon your deal. You could settle with the FTC or DOJ, or you could, try to solve the problem yourself. And so those 4 options are now down to 3 because the DOJ just does not want to settle with parties. They want to just take people to court, or they want people to just solve the problems themselves. So let me talk briefly on non-merger enforcement. There's really just one topic here I wanted to cover, which is the non-compete. Again, this goes back to the focus on labor market concerns. About a year ago, the FTC proposed a really breathtaking new rule that would prohibit virtually every employee non-compete agreement on a nationwide basis. And this would apply not only to new agreements, but existing agreements. We basically just wipe them out across the board with very small exceptions. It was sort of interesting. There were literally thousands of public comments that came in when the FTC proposed this, which just shows how much interest there is in this topic, including comments from several dozen state AGs, some of which were in favor, some of which were opposed to this. We don't know what the final rule is going to look like, but I think the FTC is going to issue some kind of a rule, perhaps with some greater exceptions than we saw with the initial proposal. I will say, again, not knowing what the final rule is going to say, I think it's safe to say that there will be a lot of legal challenges to this final rule, and that I think there will be serious legal questions about the rule. I mean, there's questions even as whether the FTC has the legal authority to issue rules like this, even putting aside the substance of the final rule. And we've seen groups like the Chamber of Commerce already basically say they're going to sue this thing the day it comes out. And I'm sure there'll be others as well. But this is a potentially very significant development, which will come out soon. And again, just for a little more context, as folks may know, non-competes have been around for a long time, employee non-competes, and they've been regulated at the state level for literally hundreds of years. And some states have outright bans on them. Most states permit them, subject to reasonableness tests. But this rule would essentially, wipe out that sort of laboratory at the state level and just apply a one size rule across the board. And I'm running a little bit over on time, so why don't I wrap up there and hand it off to Jason. And Jason, you're on mute.
Thank you, Darren. Sorry. Yeah, let's talk about what's happening outside of DC in the state and federal courthouses. Looking at the cases this year, I couldn't help but get a little bit of a retro feeling, like we may be going back to the 70s, to a time when antitrust law may have been as popular as AM radio and bell bottoms. At that time, you had a lot of concern about sort of the 60s era of the corporate conglomerate, a lot of worries throughout the political and economic realm about concentration of power. And people were trying to turn every dispute between businesses into an antitrust case. Every time competitors sued each other over some business tort, or every time a manufacturer and a distributor got into a fight over their contracts, or when consumers alleged they'd been harmed, there was a lot of interest in trying to turn those into an antitrust case. Again, people tried to find ways to slot an antitrust case into a dispute, and it wasn't hard to see why. In antitrust law, you've got treble damages, you've got attorney's fees, you've got joint and several liability among defendants, you've got virtually nationwide service of process. So there was lots of jury appeal at the time too, in terms of the idea of can you cast this as a David versus Goliath case, and a lot of jury interest in those competition issues. So there was a lot of advantage for people bringing antitrust cases at the time. But in the economic downturn of the late 70s, the tide began to turn, and rather suddenly. The Chicago school becomes more influential. More people become convinced the courts are acting as a drag on the economy. Robert Bork's book, The Antitrust Paradox, gets published in 1978, and it has a substantial influence on DOJ thinking during the Reagan years. And as that Reagan judiciary came into power in the 1980s, the bench started putting more guardrails on the way in which antitrust law could get used, and emphasizing the belief that antitrust law was designed to protect competition in general, not particular competitors or deal with necessarily individual disputes between competitors. And the courts were also, I think, scrutinizing antitrust claims a lot more carefully at the motion to dismiss stage, the motion for summary judgment stage, and screening economic experts more carefully. Eventually, the bench began, the bench's actions here, the bar began to react to it, and the temptation to reach for an antitrust claim began to ebb. Flash forward to the 2020s, everything old is new again. There's anxiety in the economy, particularly among policymakers and in academic circles, about the concentration of power and wealth again. You've got a lot of folks who are talking about the idea that competition policy may be a way to advance other policy goals, like rich-poor gap type issues. You've got the Reagan judges for whom that Chicago school Robert Bork thought process was really salient for them. A lot of those folks are retired, if not almost all of them. So your bench hostility dial got turned down a little bit. Your jury interest dial got turned up a little bit, and you also have battles going on throughout the economy between incumbent producers and new upstarts who are bringing new technology and new platforms into play. And because of that, you got disputes going on about how people ought to be able to compete. So what do we see? I think the last couple of years we've seen commercial disputes that are starting to pop up where there's a little bit more enthusiasm for asking the question, is there a competition law aspect to this dispute? Is there a way to include an antitrust claim in the case? And that's what we see in a lot of the cases that popped up this year. This year, the first one on our list is the Albemarle versus Olin case in Virginia. It's a case a little bit of emblematic about concentration in the chemicals industries. Here you've got two chemicals manufacturers, but they each rely on one another for key inputs. So Albemarle buys chlorine from Olin, and Olin buys various flame retardants from Albemarle. And Albemarle and Olin were in a dispute over a long-term chlorine supply agreement, the one that Olin is the seller on. Olin wants to reprice the deal, wants to raise the prices, and Albemarle wouldn't go along with it. So Olin sues Albemarle for breach of the supply agreement and tries to get the pricing term renegotiated. Albemarle, in response, wants to turn up the heat, and so they countersue Olin, and they claim Olin had been trying to enhance Olin's market power in the chlorine products. That was allegedly by cutting production, declaring force majeure under contracts to limit the amount of supply that was going out, dropping out of industry trade publications and data publications, which Albemarle alleged had the impact of reducing buyers' knowledge about the supply and pricing of chlorine in the marketplace. And Olin seeks initially to get the antitrust claim dismissed, but their motion to dismiss is denied. And then Olin decides that heat's been turned up against us. We're going to turn up against them. We're going to countersue. So we have a countersuit to a countersuit, in which Albemarle is now being alleged to have done the same things Olin's been doing it, but doing it on the flame retardant side for various European specified flame retardant chemicals, as opposed to Olin on chlorine. Albemarle tried to get that claim dismissed, and that motion was denied too. So both sides ended up having an antitrust claim that was live in the case, and it ends up being a bit of a throwback. Olin and Albemarle were in disagreement about commercial terms of their agreement, and it could have stayed confined to that. And I think if this had been a case brought in the 90s, it probably would have stayed confined to that. But here we got players who decided to try to turn this into a competition case, which changes the risk profile of the case. More expense, more exposure, probably a lot longer process to try to get a case like that decided. Once the motion to dismiss on the Olin counterclaim was denied, the two parties decided to patch things up, and whatever risk exposure calculus had changed led them to a place where they could reach an agreement. So the case has now been dismissed, but interesting kind of throwback. Next one up was the 10th Circuit case, Chase Manufacturing versus Johns Manville. It's another example of courts being a little bit more open to antitrust cases. Chase has a brand called Thermal Pipe Shield, or TPS. They import calcium silicate for pipe insulation, and Johns Manville is the big player in that market. They sell through distributors. So when TPS enters the market, Johns Manville decides they're going to fight back hard. They start working on advertising against the new entrant, working their customers against the new entrant, and TPS decides to go over to the courthouse. They bring a Lanham Act claim and an antitrust claim. TPS was arguing that their CalCell products were stronger and more flexible, and they wanted to challenge Johns Manville's advertising claims to the contrary. But TPS was also challenging other sales practices, including that Johns Manville was offering rebates to their distributors if they would buy their CalCell only from Johns Manville, or allegedly Johns Manville was threatening to cut off distributors if they dealt with TPS instead of dealing exclusively with Johns Manville. Now, Chase gets poured out on summary judgment at the trial court, but the 10th Circuit reverses in part. There was a tying claim that Chase was advancing at the beginning with the TPS product, and that didn't survive. But the 10th Circuit held there was a fact question about whether Johns Manville had a monopoly in the insulation product, and that there was a fact question about whether Johns Manville was making alleged threats and using the rebate program in a way that had the practical effect of keeping the TPS product out of the market. Now, I think what's interesting about this is that the 10th Circuit in the case applies a relatively loose standard on how to think about the Section 2 monopolization claims. As Darren mentioned earlier, the new guidelines that DOJ and FTC have come out with are moving towards a broader conception of some of these competition law issues. And one of the hallmarks of the old Chicago school had been try to categorize different kinds of anti-competitive conduct into narrow doctrinal boxes and apply limits around each of those doctrinal boxes about how you make a case in each one of those categories. And if you don't meet the specific requirements for that box, then your case is out. Johns Manville was arguing in this case about how to characterize the conduct at issue and how to apply the limits. And the 10th Circuit went along with it on one of the theories, the tying theory. But they also say we're going to take a look at the conduct and its impact on an overall basis. And if the court concludes competitors are being excluded from the marketplace, we're not going to ignore that just because we can't figure out which box it goes into. So here again, I think this could have been an advertising dispute, but the antitrust claim became a big part of it, and that's what it's going to be on remand. And you've got a court that's expressing interest in having a little bit broader conception about competition. The last one on this slide here concerns the Duke Energy versus NTE case. We discussed the district court decision in this case last year. NTE was building gas-fired power plants in North Carolina. They wanted to sell power to a utility in Fayetteville. And as a new power producer, of course, they needed to connect to the existing transmission network. That network was owned by a unit of Duke Energy. NTE defaulted on its interconnect agreement with Duke, and Duke sued to get overdue payments. Well, there was a reason NTE decided to default on the interconnect. It's because it decided not to build the power plant that was going to serve Fayetteville. The reason it wasn't going to build that plant was because it lost the Fayetteville contract to the incumbent provider, who happened to be Duke. When NTE went to bid for that Fayetteville utility contract, Duke offered a significant rate cut, held the business, and managed to stay in place as the incumbent provider. So when Duke sues NTE for interconnect payments, NTE counterclaims, saying that Duke was monopolizing power in that part of North Carolina. So here again, adding an antitrust claim to what would otherwise be just a business dispute arising out of antitrust of different issues. Now the court ends up dismissing the antitrust claim on summary judgment, saying that Duke hadn't excluded NTE from competition. They just won the business on the merits. And Duke had offered, after all, to interconnect NTE to the grid. So the district court's theory was Duke was just competing, not monopolizing. NTE is currently now appealing that decision, claiming that the district court's analysis of their predatory pricing claim didn't take into account all of the discounts that Duke was offering to the utility in order to keep the business. And NTE claims that had the effect of excluding them from the market. The big fight here is, was Duke pricing below its costs in order to damage a competitor? And how do you tell whether Duke is pricing below its costs? There's also an argument in the case about whether the judge ought to have recused himself because one of his former partners had appeared in the case. We'll see what's going to happen there. We expect an opinion this year. Now let me turn now to some class actions. There seems to be a lot of interest right now in the plaintiffs' bar about bringing antitrust class cases in general, but we're seeing a lot of them in other sectors like residential is very popular right now. We'll talk about some other examples in the chemical sector, but there has been a lot of activity here. A couple of examples of cases that are going on right now in the pesticide sector. We've talked about the NRA Crop Protection Products Loyalty Program case in prior years. These are cases brought against pesticide manufacturers like BASF and Syngenta. The plaintiffs contend that the manufacturers were using loyalty discounts that are paid to distributors, or loyalty rebates that are paid to distributors and to ultimate retailers, and that's supposed to keep generic products off of the shelves, per the allegations. A lot of these cases were filed around the country, and as often happens, the defendants wanted to get those cases consolidated into a single venue for pretrial purposes. Just as a practical matter, it's easier to defend a couple hundred cases if they're all in one place, on one calendar, in front of one judge. And it's often the case that you'll have both sides agreeing on the virtue of consolidation. They're just going to disagree about where it ought to be, because each side is trying to find a place that they think will be more hospitable to their side, or perhaps will be more convenient for their relevant parties. In this case, the plaintiffs wanted to be in Indiana, the defendants wanted to be in North Carolina. The judicial panel on multi-district litigation decided to pick North Carolina because you had a couple of key witnesses who were running these programs who were in North Carolina. There had been some prior FTC inquiry action that took place in North Carolina, so the panel decided it would be a more efficient place to handle the case going forward. The 10th Circuit shows up again in our next case, Black versus Occidental Petroleum. We've been watching this case for a couple of years, a case involving landowners in Wyoming who say they can't develop their minerals because Anadarko has so many drilling permits. A real problem here is that the Wyoming spacing rules are making it more difficult for smaller landowners to lease up their permits or lease up their space, because Anadarko had inherited some old railroad interests, and they had this unique checkerboard configuration for their their property. And the plaintiffs say that with those spacing rules, if Anadarko gets permits on all of their space, the neighbors are basically locked out. The district court certified a class of landowners on liability only, not damages, which is a really interesting strategy. It could be seen as a way to sidestep what is often a way that these cases, it can't get over the hurdle for class action treatment, that there won't be some way to calculate damages for the entire class on a class-wide basis. Oxy and Anadarko, they took the class certification up on appeal to the 10th Circuit and said that if you can't calculate what damages each individual member of the class has earned on a class-wide basis, you probably also can't determine if they've been injured on a class-wide basis. And you might end up having participants who were in that class who would never have been able to drill anyway, and they're not going to have any damages. They're not really injured. The 10th Circuit decided to go a little bit looser on some of the standards here and decided that just because it's possible the class would include some uninjured people doesn't mean you can't certify a class. So here again, we've got the 10th Circuit being a little more open to an antitrust claim. Seems to be a theme this year. I think in light of time, I'll skip these last two cases concerning the gas market manipulation one's been around for a long time. And the caustic soda icebreaker settlement, these were referred to in our written report. I'll take a look at, but looks like this is something that's going to be developing over the next couple of years. And the last one I'm talking about are some mixed results in some Commerce Clause cases. Dormant Commerce Clause cases are not always antitrust cases as such. The issue in a Dormant Commerce Clause case is the constitutionality of state law. A state can't adopt laws that favor its own residents engaging in commerce over people who were engaging in interstate commerce. So, it's a competition issue. It frequently pops up in antitrust related cases. But whether a given statute is neutral or biased or fair or not, whether it discriminates against out-of-state players versus in-state players, it's often not always clear. And here we've got two cases that come out different ways. In the Foresight coal case, we had the Sixth Circuit striking down a Kentucky statute that had directed utilities essentially to favor local coal suppliers. They had put a statute in place that said that utilities, when they look to buy coal, that they're going to essentially ignore severance taxes. And the reason that was important was that Kentucky coal miners have to pay heavy severance taxes. That made them less competitive versus suppliers coming from other states where those taxes weren't as high. And the legislature wanted to essentially even the playing field, so to speak, by taking their own taxes off the balance sheet. The Sixth Circuit agreed with the producer. This is obviously a case where the legislature had adopted a rule that was strictly for the benefit of in-state producers. That severance tax was clearly the deciding factor in determining whose bids were going to get accepted, and the PSC rules were obviously intended to favor Kentucky producers, and so that was the reason for that one. On the other hand, you have the district court in the Energy Michigan case saying that a local clearing requirement for electricity suppliers did pass muster under the Dormant Commerce Clause. In this case, the Michigan PSC had adopted a local clearing rule that required that if you wanted to sell power in Michigan, you had to own some local generating capacity or acquire a certain share of your generation from nearby facilities, or you'd pay a penalty. And alternative energy suppliers weren't doing that, and they're claiming this rule discriminated against them. The district court said whether you're in state or out of state, everybody's subject to the same rule about having some local capacity, and it has a local benefit. It improves grid reliability in times of peak demand, and the challengers weren't able to prove that you could satisfy that need for grid reliability with some other kind of less discriminatory approach. So it's an example of how states can defend their rules against Dormant Commerce Clause challenges, because here you had a legitimate local purpose for the regulation, not just about discriminating against particular providers in the marketplace. So that runs through the Dormant Commerce Clause cases. We've kind of come up on the end of our hour. Darren, do we have some questions that we should respond to?
Sure. Yeah, thanks. And if there are any other quick questions, please go ahead and put that in the webinar chat. We did get a question. Did the FTC consent order in the EQT quantum deal result in a readjustment of the purchase price paid by EQT for the quantum subs? The answer is not to my knowledge. And keep in mind that EQT got to keep the quantum subsidiaries. So the main deal went through just as was originally proposed. And on the backside deal, there was an adjustment there. But again, Quantum was able to at least temporarily keep that 11% equity interest. They just had to sell it off over time in a time period that was not disclosed publicly. And even on the board seat, they did not initially have a board seat. They just had a right to a board seat. So they just relinquished that right. So yeah, there really was, kind of stepping back, you might actually ask, well, why did the FTC even bring this case? Which I think is a good question. And we've seen some other cases from the FTC like this, where I think what they're really doing here, more than anything, is signaling. They're trying to let people know that these are the kind of cases they're going to try to bring in the future, right? And we see this in other areas as well. I'll give you a quick example because I didn't have a chance to cover this before. Again, on non-competes, in addition to that rulemaking, the FTC has brought some specific cases against companies that have employee non-competes. One of them involves a company that had security guards. The FTC, brought a case against them, wanting to strike down these non-competes, saying that they weren't needed for security guards. But it was really very questionable why they brought the case, because a state court had already struck down the non-compete and said it was unenforceable under state law. And the company at issue had gotten out of the security business. They'd actually sold their business off to somebody else who said they were not going to use non-competes. That wasn't their policy. And so you really kind of scratch your head and say, why is the FTC devoting enforcement resources to this? And again, a lot of these cases, not a lot, but at least some of these cases they're bringing these days are really signaling. They're sort of test cases to signal to the outside bar, hey, you need to be on the lookout for this in the future. And this goes back to my original comments to why things are less predictable today, because these sort of signaling test cases are hard to predict.
Yeah, I think that's right. And you got an administration that's interested in testing the boundaries of what it can do, and they're looking for opportunities to show where they can exercise that power and broaden their future scope. So I guess that's the year in the antitrust energy chemical sectors. We'd love to talk to you more about any of these issues. You can find us on the web. You can call us on the phone. We hope this has been helpful to you, but we're glad that you came to visit with us on a wintry day around the country. And we look forward to seeing you again at our next V&E Energy Series CLE. Thanks very much for joining us.